Here is a summary of the May 15th, 2025 Supreme Court opinion in the case called Barnes v. Felix, case number 23-1239. Whether courts should apply the moment of the threat doctrine when evaluating an excessive force claim under the Fourth Amendment. The Supreme Court wrote a unanimous opinion. Justice Kagan delivered the opinion for a unanimous court. Justice Kavanaugh filed a concurring opinion in which Justices Thomas, Alito, and Barrett joined. Please note that this summary is read by an automated voice.
Justice Kagan's unanimous opinion, Respondent Roberto Felix Jr., a law enforcement officer, pulled over Ashtian Barnes for suspected toll violations. Felix ordered Barnes to exit the vehicle, but Barnes began to drive away. As the car began to move forward, Felix jumped onto its doorsill and fired 2 shots inside. Barnes was fatally hit, but managed to stop the car. About 5 seconds elapsed between when the car started moving and when it stopped. 2 seconds passed between the moment Felix stepped on the doorsill and the moment he fired his first shot. Barnes's mother sued Felix on Barnes's behalf, alleging that Felix violated Barnes's Fourth Amendment right against excessive force. The district court granted summary judgment to Felix, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. Under the rule, events leading up to the shooting are not relevant. Here, the precise moment of threat was the 2 seconds when Felix was clinging to a moving car. Because Felix could then have reasonably believed his life in danger, the panel held the shooting was lawful. Held. A claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. Most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. Plumhoff v. Rickard, 572 U.S. 765, well illustrates this point. There, an officer's use of deadly force was justified at the moment, partly because of what had transpired in the preceding period. The moment of threat rule applied below prevents that sort of attention to context and thus conflicts with this court's instruction to analyze the totality of the circumstances. By limiting their view to the 2 seconds before the shooting, the lower courts could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier interactions between the suspect and officer, and because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set within a longer time frame. A rule like that, which precludes consideration of prior events in assessing a police shooting, is not reconcilable with the fact-dependent and context-sensitive approach this court has prescribed. A court deciding a use of force case cannot review the totality of the circumstances if it has put on chronological blinders. The court does not address a separate question about whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis. The courts below never confronted that issue, and it was not the basis of the petition for certiorari. Vacated and remanded.
Justice Kavanaugh concurring opinion. I join the court's opinion. I agree that the officer's actions during the traffic stop in this case should be assessed based on the totality of the circumstances. I write separately to add a few points about the dangers of traffic stops for police officers, particularly when, as here, the driver pulls away in the midst of the stop. Even for routine traffic violations, traffic stops are fraught with danger to police officers. An inordinate risk confronts an officer as he approaches a person seated in an automobile. That is in part because officers operate at a tactical disadvantage when approaching an unknown vehicle with limited visibility and unpredictable threats. Officers cannot let their guard down and assume that any particular traffic stop will be safe, even if a driver is pulled over for nothing more than a speeding violation, a broken tail light, or the like. The driver may be drunk, on drugs, armed, or some combination thereof. Or the driver may have committed, or may be about to commit, a serious crime. People detained for minor offenses, such as ordinary traffic violations, can turn out to be the most devious and dangerous criminals. So even though most traffic stops end without incident, traffic stops are nonetheless inherently risky for police officers. And when, as in this case, the driver suddenly pulls away in the midst of a stop, the risks multiply. A driver speeding away from a traffic stop could easily endanger bystanders and other drivers, especially if the fleeing driver is under the influence of alcohol or drugs, as might well be the case when a driver flees. Moreover, the very fact that a suspect flees when suspected of a minor offense, such as speeding or a failure to pay tolls, could well be indicative of a larger danger. What should the officer do when a driver flees from a traffic stop? There are no easy or risk-free answers. Every feasible option poses some potential danger to the officer, the driver, or the public at large, and often to all three. And an officer in that situation must make a split-second choice among those various dangerous options. First, the officer could simply let the driver go. But because the fleeing driver might be a threat to the community, letting the driver go may exacerbate the dangers rather than mitigate them. Encouraging officers to stand back and allow drivers to take off would also create perverse incentives for those who are stopped by the police. Second, the officer could get back in his police car and give chase, or could radio other officers to pursue the driver. But a high-speed chase likewise can be exceptionally dangerous to the officer, the driver, and others on the road. Vehicular pursuits are often catastrophic. Third, the officer might try to shoot out the tires of the fleeing car, or otherwise try to hinder the car's movement in order to bring it to a stop. But shooting at a car, especially its tires, can be dangerous and is often ineffective. Even if the officer manages to hit the tires, the driver could lose control and crash into others on the road. That course of action also poses the risk of the officer accidentally shooting the driver or innocent passengers. Fourth, as happened here, the officer could attempt to stop the fleeing driver at the outset by jumping on or reaching into the car. The dangerousness of that option is readily apparent. Perhaps the driver will hit the brakes once he realizes an officer is clinging to the car or attempting to reach through the window. I could go on. The point here is that when a driver abruptly pulls away during a traffic stop, an officer has no particularly good or safe options. None of the options available to the officer avoids danger to the community, and all of them require life or death decisions that must be made in a few seconds in highly stressful and unpredictable circumstances. Of course, when an officer uses force against a fleeing driver, the judiciary still must assess any resulting Fourth Amendment claim under the standard of objective reasonableness. Under this court's precedents, that inquiry involves a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing governmental interests at stake. In conducting that analysis, judges should keep in mind that it is one thing to dissect and scrutinize an officer's actions with the 20/20 vision of hindsight in the peace of a judge's chambers. It is quite another to make split-second judgments on the ground in circumstances that are tense, uncertain, and rapidly evolving. In analyzing the reasonableness of an officer's conduct at a traffic stop, particularly traffic stops where the driver has suddenly pulled away, courts must appreciate the extraordinary dangers and risks facing police officers and the community at large.
Case implications. The court's unanimous rejection of the Fifth Circuit's moment of threat rule reaffirms the requirement that lower courts consider the totality of circumstances leading up to a use of force incident, rather than limiting their analysis to just the precise moment when force was used. This broader analytical framework may lead to more nuanced and context-dependent evaluations of police conduct, potentially affecting both law enforcement training and judicial review of excessive force claims. However, Justice Kavanaugh's concurrence, joined by 3 other justices, emphasizes the inherent dangers officers face during traffic stops and the split-second decisions they must make when drivers flee, suggesting that while courts must consider the full context, they should remain mindful of the practical challenges and risks officers face. The tension between these two perspectives, the majority's emphasis on comprehensive analysis and the concurrence's focus on officer safety, will likely shape how lower courts apply this precedent in future cases.